5 seconds to go. Start. Vikram Ratnu PW3 also identified Firdoskhan A2 as the second man who had escaped from the spot. Learned counsel for the respondents further contended that the discrepancy sought to be exploited by the learned counsel for the appellant in the statement of Vikram Ratnu PW3, wherein it is mentioned that the contraband articles were found in Ahmedabad unattended, was explained by the witness in his further examination, wherein he stated that it was not true that the Mudamal was found lying abandoned. Thus, as per the learned counsel, the prosecution has proved its case against both the accused beyond all manner of doubt, and that the conviction of the accused, as recorded by the trial court and affirmed by the High Court, does not warrant any interference by this court. On these grounds, learned counsel for the respondents implored the court to dismiss both the appeals. We have given our thoughtful consideration to the submissions advanced at bar and have gone through the impugned judgment. We have also thoroughly reappreciated the evidence available on record. At the outset, we may note that the contention of learned counsel for the appellants that the search and seizure was undertaken without associating an independent witness is untenable on the face of record. Mannu Bhai PW1, the punch witness associated in the search and seizure proceedings, was serving in the income tax department, and hence by no stretch of imagination can it be accepted that the witness was a stock witness of the NCB or was an interested witness. Mannu Bhai PW1 in his sworn testimony proved the recovery Panchnama Exhibit P30 and also fully supported the prosecution case regarding the search and seizure of contraband effected from Anwar Khan A1. Nothing significant could be elicited by the defense in the prolonged cross-examination undertaken from Mannu Bhai PW1, and hence we have no hesitation in holding that the evidence of Mannu Bhai PW1 being the punch witness associated in the search and seizure effected from Anwar Khan A1 is reliable and trustworthy. Thus, it is well established that independent punch witness was associated in the search and seizure procedure. It was the fervent contention of learned counsel for the appellants that the search and seizure proceedings are vitiated on account of non-compliance of the mandatory procedure provided under Section 42 of the NDPS Act. The said contention is on the face of record misplaced. The secret information which was received by Deepak Parikh PW2 was to the effect that two suspects would be bringing contraband substance at the ST bus stand Kheda, which is a public place. Section 42 of the NDPS Act deals with search and seizure from a building, conveyance or enclosed place. When the search and seizure is effected from a public place, the provisions of Section 43 of the NDPS Act would apply, and hence there is no merit in the contention of learned counsel for the appellants that non-compliance of the requirement of Section 42(2) vitiates the search and seizure. Hence, the said contention is noted to be rejected. So far as the contention of learned counsel for the appellants that the search and seizure proceedings are vitiated on account of the non-compliance of Section 50 of the NDPS Act is concerned, the same is also noted to be rejected because admittedly the seizure in this case was not effected during personal search of the appellant Anwar Khan A1. Admittedly, the contraband was being carried in a polythene bag held by the appellant Anwar Khan A1 in his hand, and hence there was no requirement for the seizure officer to have acted under the provisions of Section 50 of the NDPS Act before conducting the search and seizure proceedings. Stop.